Hello and welcome to Afrocentric Television. On today's edition, we are going to be facing immigration issues. And today we'll focus strictly on deportation. As you know, it's been a lot of issue in the United States, and you know this administration, this current administration, is doing I don't know how to qualify that, but families are being separated. You know, it's just a proceeding. It's a lot has been happening that, you know, it's affecting the lives of people in Houston and in the United States as a whole. So today we will be bringing in one of my personal friends to talk about his experience and some of the people that he knows that we can reference to, so it becomes a real life situation for you guys that you can relate to, right? And also a professional, of course, someone that knows what he's doing when it comes to deportation. He is the staff attorney for the Advanced Immigration Clinic, which is part of Deportation Defense Houston, and he's with South Texas College of Law, right?
Yes.
In Houston here, and by the name of Jose Luis Martinez. Welcome to the show.
Thank you.
And of course, my friend, Mr. Olaleye, Hakim Shegun Olaleye. Welcome also.
Thank you very much.
I will start with you, Mr.
Okay.
Lewis.
Sure.
First off, before I dive deep, let me get you to introduce yourself properly,
Sure.
to our viewers.
Yes, and thank you. So my name is Jose Luis Martinez, and I work with, as you stated, I work at South Texas College of Law Houston for the Advanced Immigration Clinic, which is a part of a larger project, Deportation Defense Houston, which is a collaborative of various nonprofit organizations in Houston. So what we do is our focus is defending detained individuals in the Houston detention facilities.
So they are already detained individuals, you said?
Correct.
Before people get detained, there are processes that have to be in place.
Yes.
You must have been written off by the government to say you're not fit to stay in the United States. You have to go back to wherever you came from, outside of the United States. That's why you're facing deportation. So what are the things that could lead to that?
So there's many things that can, so, you know, as you stated, you may have been here in the United States for some time already, and something happens, perhaps you don't have lawful permission to be in the United States, and you encounter an immigration enforcement agency. They then, it's up to them, but they do have the power to arrest an individual that's not in the United States with permission. Also, too, you could be here legally, but something intervening may have occurred. You may have had some kind of criminal charge, a criminal conviction, or some other things that may have happened that may have caused you to lose your status or put you in a position where the government can revoke your status. So that's one class of individuals, people that are already here that the government is looking to remove from the United States. There's also another class of individuals that are seeking to come to the United States that the government is saying, alleging that they don't have permission to come into the United States. So you see this a lot with individuals who present themselves to request asylum.
So, if you're already here and you did not commit any crime for the first 2 years, so to say, am I still, you know, up for deportation if nothing had happened, if I didn't commit any crime? Just because I'm here, I've overstayed my visa, to stay. I've not committed any crime whatsoever. You know.
Yes, unfortunately, you know, if you no longer have permission to be in the United States, regardless of how long has passed, it could be a day or two even, but if you no longer have that permission to be in the United States, you can be detained and removed from the United States, regardless of the time period.
So by permission, you are referring to overstaying your I-94, pretty much. That's what it is, right?
Normally, yeah, and so the 994, usually you came in on a visa, or you're granted some type of permission to enter the United States, you're given the I-94, which is, you know, your permission that you can be here 6 months, 1 year, whatever it might be, and so when that expires, you no longer have permission in the United States, and you can be removed.
If I may quickly ask, I mean, we're talking deportation now. For the benefit of those that have overstayed their visas or that have overstayed their I-94, but they still have valid visas, what are their chances of not being deported?
And that's a really good question, and something that a lot of people confuse. So there's the visa, and then there's the I-94. These are not the same thing. So you can think of a visa kind of as a key to get into a house. You can think of the I-94 as your permission to stay in the house. So the visa allows you to leave and come back to the United States, but it does not dictate how long. I shouldn't say that. The visa itself doesn't state how long you can be in the U.S. You will get that on the I-94, and that's what Customs and Border Patrol would typically give you.
So if I get the I-94, typically, if they believe, okay, he's here, he's good, they give you like 6 months. That's 180 days, I believe, right? Within that 180 days, can I file for an extension? And what are the conditions?
Yes, and so 180 days is usually what's given for visitor visas. But you may be coming on a work visa, you may be coming in on something else. So we'll take the example with the visitor visa. You enter on the visitor visa, give you 6 months. You can apply for an extension. You do need to apply within that 6-month period before it expires. Unfortunately, because of the backlogs at USCIS, you may not actually get a response within the next 6 months.
So what happens within that time frame?
It's been changing with this administration. In the past, those individuals, as long as you file for an extension and it's not a frivolous application, you're considered to be maintaining your status because you timely apply.
The same status, irrespective if I were stayed 6 months.
Right.
Because the delay is coming from them.
From the immigration, yeah.
Exactly. That's not necessarily as true as it used to be. One of the issues that we see a lot with these visitor visa extensions is that you are probably not going to get a decision within the 6 months because it's usually 6 months increments that they give you. And so what happens is you fall out of status, even if they approve it, and it may already be past the time for you to leave on the next extension.
And the next extension, and that still falls back on me.
Right, exactly.
Oh wow! But I mean, you see what I'm saying now? I mean, it becomes like a setup, if you ask me. Say, okay, I apply for a visa from where I'm coming from. You granted me a visa, 2 years,
2 years.
multiple entry visa. I came in for the first time or second time, however number of time I've been here. At the port of entry, you stamped my passport and you gave me a I-94 that allowed me to stay within 6 months. For some reason, I think I need to extend my stay. I filed to extend that. I did not mean to overstay, but because I want to do it legally, I filed with you to extend that stay that you granted me. Because you have a backlog, right? You count me that my status is still valid, for whatever reason. Now, by the time you granted my extension to stay maybe 3 months, an additional 6 months, it's over that 3 or 6 months.
Right.
And now it's again time for proceeding for me to leave the country. Yeah. And I didn't know that. I didn't know that. So how do we get such information? Do I call immigration consistently just to get on the status? At which point you're probably talking to an automated machine. Right, it's going to be very, very difficult for you to get a human on the phone. So what are my chances then, without being termed as someone that has violated their stay?
So usually in that position, we might actually recommend that individual leave within that 6 months, if possible, and then come back at a later time, because then they'll be given a new I-94 with a new 6 month period, or whatever period it might be.
You're coming from Africa, man. The cheapest flight you're gonna get at some point in time is over $1,000 round trip.
Right. And sometimes, there are some exceptions to filing timely. If you can show, in the past, if you can show, there is some illness or something that kept you from filing within that time period, there is some room for discretion on USCIS's side. It gets harder and harder as time goes by to convince them to exercise their discretion. But in some instances it can. You can also try filing another extension, but whether or not that other extension will get approved. And so these are the issues that we're dealing with. It doesn't seem like the current procedures are set up to make an individual's life easier, unfortunately. And so
unfortunately,
this is the system we have to deal with, unfortunately. Of course, too, I would suggest that individuals talk to an immigration attorney and see if there's some other status they might be able to apply for that would allow for more than 6 months. Sometimes people come to the United States, they get a job offer, so maybe they can, turn that visitor visa into some kind of work visa, in which case it won't be 6 months, it might be a year, it might be 2 years, it might be longer. Maybe education is an option for them.
Education is where I'm coming at next. So I'm here on a U.S. student visa.
Student visa.
For some reason, international students obviously pay, if not 3 or 4 times more than
what the in-state pays.
So I'm paying that tuition. My first year or my first semester, I was able to afford that. Don't forget, they usually give you a Social Security card with a restriction on it that you can only work for about 20 hours a week. You can do that job within the school or within some there's certain restrictions comes to that. However, 6 months goes by after my first semester or second semester or whatever, I can no longer afford to pay
the school fees.
Now I have to withdraw from school temporarily. What are my chances of reinstatement back to school? Because that I-20 states that you have to be in school, and the school have to report
that you are in school.
That you're in school. And if you are not, they will report that also.
That you're not in school.
So what happens? For some reason, life happens, right? My parents or wherever my source of financial support is coming from, it may deem slow at the time. Life happens, like we said, right? Now what happens to me? I didn't mean to be illegal in the United States, but
yeah, and so I started saying I really don't do much of F1s, but unfortunately, the laws aren't really written in a way to be as forgiving in those situations as we wish it would. So if you do fall out of status, there is a mechanism to ask for reinstatement. There's a procedure. It's not a very simple one. There is a procedure. I think it has to be within a year or something like that. And there is an opportunity for that. I don't do much with that, so I can't go into detail what that is. But going back to your earlier statement, life happens, and sometimes you fall out of status, sometimes you violate your status. And unfortunately for us, our laws aren't very forgiving on that point. Sometimes
they're not very forgiving.
They are not. And sometimes you can find exceptions, but generally speaking, if you fall out of status, you start accruing what we call unlawful presence. Basically, you don't have permission to be in the United States anymore. It's a little bit different with the F1 students because their I-94s aren't for a certain time. For instance, a visitor visa, you get 6 months. But with a student visa, they give you what they call duration of status.
Yes.
So essentially, you are in status as long as you're still in school. So it's a little bit more forgiving with the F1 student visa because and I think this is going to get changed in the administration, but normally you're not considered to be accruing unlawful presence when you fall out of school,
status
under the student visa.
So how about marriage? We talked about F1, we talked about visitor
visa.
Now, I'm here in the United States. I'm married to a United States citizen. Because there was this gentleman, I believe, from Ireland, I think. He has 2 children, maybe the third one, he just gave back to the third one. But because he had marijuana when he was little, when he was still very young, a minor, it counted against him about 10, 15 years later.
Yeah. And again, the immigration laws are not very forgiving in most circumstances.
Even though marijuana is legal in some states?
It's legal in some states, but it's not legal federally.
Okay.
And that's where the problem is, right? It's not.
But they changed the law, isn't?
But immigration is the same all around the United States, right?
Correct.
It's
a
not
federal
state
law.
by state. It's a federal
Right.
law.
It's federal law.
Right.
So yes, absolutely. And so to answer your question about marriage, a lot of people mistakenly believe that marriage to a U.S. citizen is enough to get, your green card, your residency, but that's simply not true. It's just one.
It is not true.
It is not true. It is one element. It's just one piece of the things that you need to get your green card in the United States. So going back to the example of the Irish individual, So, typically if you marry a U.S. citizen to get your green card, your residency, you have to have, one, entered the country lawfully. Two, you have to have that relationship such as marriage.
Before you go further, is there another way to enter into a country unlawfully?
Yes, absolutely. So when we say lawfully, it actually embodies a large case law, so I'm not going to go too deep into it. But when I say lawfully, the most common method is you come in on a visa. You come in on some kind of visa. So you had permission to come here, right?
Yes.
And the most common example of when you enter unlawfully without permission is you just cross the border somewhere.
Oh,
you didn't have permission.
with someone. Yeah.
So while we're still talking marriage and immigration, now there are two types of marriages. Let me just explain in my own lay term. In a situation where you got married to a U.S. citizen and the person filed for you while you were outside the country, probably you were married back in Nigeria, she brought you into the country. If the marriage goes bad and you end up going through deportation, if the marriage goes bad, the marriage did not work out, and they ask you to leave based on the fact that you got married to this person, the marriage did not work out, you have to go back and come back. What's the difference between that marriage and the marriage you meet someone in the US, you fell in love, you got married in good faith, and the marriage did not work out? What's the difference between both of them?
Well, so the processes are going to be different, right? So if you get married overseas, then you're going to apply through a consulate, and then you do the interview at the consulate. If everything goes well, then you get the immigrant visa to come to the United States. And then once you enter the United States, you get your residency.
90 days to file, then.
Well, that's for the fiance visa.
Fiance, okay.
But generally speaking, so if you have a marriage to a U.S. citizen, you do it overseas. It's just the process is mainly what's different. The legal aspect's usually the same. But to go back to your question, if in both cases, it was a good faith marriage and they entered both in a good faith marriage, they get married, they're approved for residency. Typically, the marriage falling apart is not what's going to cause that person to lose their residency if they can prove that it was entered in good faith. And that wouldn't be cause for it, as long as it's already been approved. If instead they're in the process of applying and they divorce before a decision is made on the residency, then that would cause the residency application to be denied.
What if there was an abuse?
So
by
by the spouse.
Okay, yeah.
Right. So I'm married to a lady. She's been abusing me, but because I know my residency depends on our marriage, right? And genuinely, we established this union in good faith, like you said.
Right.
But now things gone sour. Is that a ground? I mean, this is with abuse in it. Is that a ground for me to lose my status just because
the marriage is not working out?
And so again, the test,
and I'm able to establish the fact that the abuse is there. There's been police report. There's been all of these things. This record showing and indicating that it wasn't all my fault. It has always been her. And even if it was the case that I'm the citizen and abusing her, is there a ground for them to throw me out just because that's my life wasted just because?
And so so the situation with sometimes citizen, assuming that you've already received your green card, is sometimes if it's a new marriage within 2 years, they give you what they call conditional permanent residence, which is a 2-year green card. And at the end of the 2 years, you and your spouse are supposed to file to remove the conditions. And at that time, they look to see, hey, are you still married? And so sometimes that's when issues come up. But if there has been abuse, you can get an exception to having to have your spouse's signature on the condition, on the application to remove those conditions.
And what if she refuses to sign it
they don't want to. I don't want you anymore, so I don't want to support anything. In fact,
and the spouse, either the lady or the guy, refused to sign. Yes.
Yeah, and so there are exceptions. Abuse is one of them. In that case, I would suggest that individual go through the process of divorce, because divorce is also an exception to having that second signature. Of course, you will again have to show that at the time you entered into the marriage, it was in good faith.
Good faith, okay.
But there are exceptions to that.
So what are other conditions? I know you said that's one of them. What are other conditions that could grant me stay if I'm in a relationship in the United States. I'm married to somebody, and the relationship went sour, and I've changed my life. I've moved I left my job, whatever it is that I was doing, my business, to move down here, and I'm here now. It just never worked.
Yeah, and so let's take, for example, that happened, right? And that individual kept promising, I'll file your papers for you, I'll file your documents for you, right? And then they never do. They hold it over you, they're abusive, they hold your status against you. That might be a case for VAWA, Violence Against Women Act. And under VAWA, you can still get your residency.
You said Women Act. So does it...
I was actually going to ask if it applies to men.
Men don't cry, they say. So, right? So if I'm a guy, my wife is abusive. She slaps me, she kicks me around. If I'm trying to look for a job, she wants me to babysit.
Right.
I've tried to be the man, but she's enjoying being the boss. It's not working well.
So do men benefit from VAWA?
There you go.
Yes, they do. And the name of the act is the Violence Against Women's Act, but it also applies to men as well. You don't see as many men apply for it, but it does apply to both sexes.
So because it's labeled women, so
right, and that's just the name of the act, the bill that was passed years ago.
Okay, so let me ask a question. Let's assume someone gets a letter for deportation.
Okay.
You are given voluntary deportation.
Okay.
60 days, 90 days, 180 days, 6 months to voluntarily depart. And the person probably did not get the letter on time to be able to meet up with the 180 days to voluntarily depart. What should that person do at that point in time? One, and my second question is, let's say there's anybody that gets a deportation notice, a deportation letter. What are the necessary steps you think they need to take? Now, because a lot of people, once they get that letter, they are always afraid to probably appear, to talk to a lawyer, to talk to somebody, the fear of being deported. What do you think they should do? What are the necessary steps they need to take? Yeah, and if there are appeals, they can.
Okay, so those are great questions. So let's take it. Let's assume that they're not in. Let's assume they're applying for something like a green card or something. Like that. So they're working with USCIS at this point. And so if that application is denied, and the denial of that application means they have no status, no permission to be in the U.S., a letter is sent, and it said that you must depart within, depending on what it was you applied for, depending on what you had before. It might say, at earliest as possible. It might say within 30 days. It varies depending on your circumstances. Normally, for most applications, you do have a period of 30 days to either appeal or do what we refer to as a motion to reopen, motion to reconsider, which is basically asking them to take a second look at the case.
What is the wait time?
It varies. It varies on what the application is, and it varies on who is going to make a decision on that.
So does the letter specifically state you have 30 days?
From certain date?
Yes,
right.
to appeal. And what if you don't get the letter within the time frame?
Yeah, and so if you don't get the letter, sometimes there is some discretion that they can allow you to still file late.
Okay.
But I would be very hesitant to do that. I would try my best to get that filed on time if possible. But if you can show that you didn't receive that, there are mechanisms to ask that the case be reopened, or ask them to accept whatever it is you're filing, whether it be an appeal, motion to reconsider. You maybe not be able to, depending on what it is, you may be able to file that late. I would start with asking them to do what we call a motion to reopen.
Okay.
Hey, please reopen this case. I never got the denial notice. If they send you a new denial notice or they reopen the case, that'll give you another timeline to put you back within, so that way you don't miss that filing deadline. So
we'll go on a break shortly, but before then, we have two questions that I need you to tackle for me.
Sure, absolutely.
And one of which is asylum.
Okay.
Right. Asylum, I moved to the United States, or rather I came to the United States on a visiting visa or whatever. And before you know it, I'm able to establish that, God forbid, someone from my home has been terrorized by one of these, it could be whatever religious organization or one of these Boko Haram kind of organization out there. And I'm afraid to go back. Is that a ground for me to file for asylum?
It's a really complicated question, actually. So asylum is very complicated. But generally speaking, and this is very general, that if you have, fear of persecution if you return to your country, then generally, yes, you do have the right to apply for asylum. I would highly suggest that you meet with an attorney first, because there's certain things that you want to make sure that are there before you apply for asylum. A lot of people, to say that you have a fear of returning to your country because there's a lot of violence in your country, that's usually not going to be sufficient for asylum. If instead you have a fear of returning to your country because somebody's directly threatening you or your family, now we have a much better application for asylum. So general violence typically isn't going to be enough to get you asylum.
Even if it is within the vicinity where I live?
Correct, unless it's directed towards a group that you're a part of. Maybe you're a part of some kind of minority group in your country. For instance, maybe you're an indigenous individual and there's persecution of your clan, your tribe, your race in that country, or you're part of a minority religion that's being persecuted in that country. So that would be different. Now you're part of a group that is being persecuted. But to say that everybody is afraid of the general violence is usually not enough for asylum. It has to be something particular to you or some group that you're a part of.
So you have to be directly affected.
Directly affected, or again, part of a group that's directly affected.
Okay.
And that could, in some cases, that could include, someone in your family is being persecuted and they're threatening the family as well. Or again, you're part of some minority group, whether it be religious, race, or you're part of some opposition political party, things like that.
So I want to talk about instant deportation, right? Say I'm somewhere, I am driving somewhere and I got pulled over. Maybe I didn't signal. I was trying to make a right turn, I didn't signal to get on that lane. I got on there, police pulled me over, and is it possible for them to hand me over to ICE? Because I heard, I think it's a SB4 or something like that, that there are some counties within the Houston metro area that police can pull you over and ask you immigration questions.
Yeah, and unfortunately that is something that does happen. My advice to anybody that gets pulled over by local police, local sheriffs, and they ask you questions related to your alienage, that is where you're from, is to just answer nothing. Because once you get to the immigration court proceedings, let's say for instance you do get arrested, you are put into jail, and then the next day ICE picks you up from jail, right, and you go over to immigration jail. It is ICE's burden to prove that you are from a specific country. So if you don't tell them, where you're from, ICE has to try to figure that out, and if they can't figure that out, there's potential there to terminate your proceedings and get you out. And so but unfortunately most people...
I need you to please tell my audience that, or my viewers that, because I asked that for a specific reason. In Houston, I learned the mayor is doing a very, very good job, along with the chief of police at Acevedo. They're doing a very good job to protect at least their residents within the Harris County area, that if a police pull you over, they do not have that right. I think that's a SB4 or something like that. They do not have that right to ask you of your immigration status. However, if you fall within those counties, because that's in the whole of the United States now, that can ask you, and the police actually ask you, and you refuse to talk, they take you in. After treating whatever they took you in for, which is maybe a traffic ticket or whatever, then they hand you over to ICE, right? They hand you over to ICE, ICE takes over. If whatever you say can and may or will be used against you in the court of law. Yeah. So, but if you remain quiet, I need to take it on from there. If you remain quiet, what happens?
Yeah, and so again, it is the government's burden, Department of Homeland Security, ICE, it is their burden to prove not only that you're not a citizen in the United States, not only that you're not here with permission, but they have to prove where you're from. They have to prove that specific country. And so a lot of times what we see is the police officer asks, they may not ask, are you a citizen, but hey, where are you from? And you'll say, Mexico, Nigeria, Uganda, Ireland.
The moment you mention a country, they establish where you're from.
Yeah, and but the other thing that we see a lot too is that individual will have their passport on them, their consular ID, And so during the search of their person, that may come up, and now the police officer will be like, oh, we found his Irish passport, or we found his
Nigerian passport.
Yeah. And so that can work against you, but the more you say, the more it's going to work against you. So it's in those situations, it's always better to just not say anything, and just let them go through the burden of trying to figure out where you're from.
But if they cannot establish it, they still have to let you go.
So by you not saying anything, are you committing any offense? Are you committing any crime?
No, you're not.
Because they'll tell you, you have the right to remain quiet.
Okay.
Yeah, so you have the absolute right to
Yeah,
be silent.
until you have an attorney or you want an attorney present or something,
And then once you get to the immigration side, again, you don't have to actually say anything to them. And they'll try to get it out of you. They'll threaten you this, that, and the other. But if they can't prove where you're from, the attorney, myself, or whoever it may be, we have a much better chance of getting you out. Because they have to do that. If they can't do that, we can terminate proceedings.
How long?
Is there a time frame? That was going to be my next question.
How long can they hold me for before if they can't put that out from me? How long can they detain me for?
Unfortunately, in that case, it would probably have to wait until we can get in front of the immigration judge to make that decision. That hey, they weren't able to carry their burden. So that could take some months, weeks, months, depending on the individual. Depending on which court they're in, it may be a few weeks, maybe a few months.
Anyway, when we come back, we will be talking about sanctuary states, right? We'll be talking some more about deportation from the United States, not just the Houston, because this is affecting, it does not matter if you're African, if you're Irish or European, whatever that may be, if you're North American or South American, it does not really matter right about now. In America, it cuts across every race and ethnicity. So when we come back, we'll be talking to Jose Luis Martinez some more about the deportation proceedings and how we can better prepare and protect ourselves. For the meantime, in the meantime, stay tuned.
Welcome to CFAX Global Logistics, where your ultimate satisfaction is our goal. We make your shipping needs a worthwhile experience. As a licensed freight forwarder, CFAX Global Logistics offers air and sea freight, procurement and supply chain, project logistics, warehousing and storage services. Call us at 281-820-9000 or 832-593-3067. We offer prompt, effective, qualitative services, and damage-proof delivery is our guarantee. What's more, we offer the lowest competitive rate for your shipment. You can call us at 281-820-9000 or 832-593-3067. So, to ship your next products and goods across continents on the next available flight or ship at a price that can't be beat, come to our office located at 8180 Southwest Freeway, Houston, Texas 77074 for your shipment and logistics services. CFAX Global Logistics, the trustworthy and reliable partner for your logistic need.
Welcome back to Afrocentric Television Channel 15.8. It's been on immigration issues, as you've been hearing, and then we are back to even talk some more about the sanctuary states in the United States. I know New York and probably New Jersey and a few other states are part of sanctuary states, but let's hear it from our guest here, Mr. Luis Martinez. No, it's Jose Luis Martinez. Yes, I need to say it right, in that order. And of course, our guest host, Mr. Shegun Akimolale. So welcome back, guys. So, tell me, what is a sanctuary state?
Yeah, and so It means a lot of different things to a lot of different people. I don't think that there's just one definition, but generally speaking, when we say something like sanctuary city, sanctuary state, it's cities, states, counties, jurisdictions that are going to limit how much they are assisting ICE and other other DHS agencies in their apprehension of non-citizens. So, for instance, there was a time where it was very uniform that somebody would be arrested, they would contact ICE if they didn't think that individual was a non-citizen. So some of these sanctuary cities limit when they may contact an individual, or when they may contact ICE when they arrest somebody they think may not be a citizen of the United States.
But if I was a police officer and I just don't like you,
and that's one of the issues. They can, as a private individual, they can just call ICE. Unfortunately.
But if I'm a police officer,
right,
and I just don't like you,
and then they think you're not a citizen, they can call ICE. Unfortunately, that is something they can do.
How can they think you're not a citizen?
What?
How can they know you're not a citizen?
That's a case now. I think something just happened recently. I spoke with Julie about this via email. One of the things is, so based on your assumption, you may just assume that
I don't think he's a citizen.
I'm not a citizen. And once apprehended, I could face deportation.
Yeah, and that's a really big issue, right? What we see a lot in my practice is race-based stops, right? You'll see individuals turned over to ICE for things like speeding, didn't indicate they're returning, illegal turn, illegal U-turn, simple things that you would never consider somebody else to be pulled over for. You'll see these individuals not only pulled over for, but arrested, taken to jail, and then ICE is contacted. And so these tend to be race-based stops, right? There's assumptions about how a person looks, maybe the language they're speaking, what they're driving, what they're wearing. People make assumptions about where they are with this information, and then they find, and I shouldn't say always, right? But sometimes they're pulled over for something else, and the police officer might get an indication that this individual might not be a citizen, and instead of just writing them a ticket and letting them go, maybe now they have to go back to the jail and ICE is contacted. We do see that sometimes, unfortunately.
So where in the United States safe? Where is safe?
And I mean, ICE can really, come and detain somebody without permission anywhere in the United States. There are some, safe zones and things. There's some guidelines that were implemented years ago.
Do they actually follow those guidelines?
It's not really clear. Usually those type of things fall under, ICE usually doesn't really give us much information when it comes to those things because it's considered, confidential security information. So, but a while back there were guidelines stating that churches and other areas, right, they shouldn't, and it was more of a shouldn't than won't, right? You should not go into a church to arrest somebody. Whether or not that's still being followed, really don't know.
So I know in 2018, October 1st precisely, Attorney General Jeff Sessions was given the order to quicken or to make processes faster. If I'm reading a letter, say it's going to take 90 days for them to get to my hearing, but because of the expedition, can ICE just come just because they feel like, okay, on papers I have 90 days, but the AG has signed it that it has to be quicker, we have to attend to them in the next 30 days, and if your case is not attended to, am I going to get a chance to get to my hearing?
And so that's going to really vary on a case by case basis. So if you, let's say for instance, you're somebody in the United States who already has a removal order, ICE comes to get you, they're probably going to remove you fairly quickly, unless you can do something to reopen the old case, or you have some grounds for asylum, or what we call withholding removal, which is very similar to asylum. It deals with persecution. But if you don't have any grounds for any of those, and you already have a removal order, and then it can be a fairly quick process to detain an individual and move to the United States.
So best thing is to always turn to an attorney.
Absolutely.
An immigration attorney.
Absolutely.
At this point, because I know a lot of my people, when I say my people, I mean people from Africa, they do a lot of DIYs, right? Mm-hmm. They read through the whole procedure, they understand it, they do the filing for themselves, mm-hmm. right? And 9 out of 10 times they win, right? They get an approval and whatnot. However, the way it's going now, can you even file for yourself without an attorney?
I don't recommend
it's not advised. It's not recommended, right?
And one of the reasons I say that is, I think within the last year, they started implementing. They sent out new guidance to USCIS, where they're going to start increasing when they issue what we call notice to appears. Notice to appears are the charging documents from immigration court. And so USCIS has always had the power to issue the power to put people into immigration court proceedings, but within the last year there's new guidance that's going to increase when that happens. So for instance, maybe you apply for your green card and it's denied and you no longer are in status, whatever status you had before, maybe you didn't have status before, it's now within it's always been within the power, but now there's guidance that says that it may happen more often, that instead of just saying, hey, it's time to go home, they're actually going to put you in immigration court proceedings.
Is anywhere safe? I asked that before, but on the road, in the air, to travel?
So there's always a risk traveling when you don't have permission to be in the United States. Like we discussed earlier, you could be driving, they might get pulled over for speeding, you might get pulled over for not using your turn signal, and that could start, get you arrested, sent you over to ICE. Typically, when you're flying domestically, you're not going to go through customs. You're not going to encounter Customs and Border Patrol or ICE. But I don't know if you remember, but about a year or two ago, there was a flight, and domestic flight, as the people were disembarking, there were two Department of Homeland Security agents that were checking everyone's IDs. This is not common. But
at the airport?
Yeah, and there've been.
So I flew in from New York to Houston. When I'm disembarking the plane, I have two officers waiting right there just to check my ID.
Yeah.
But I have 3, 4, 5 Caucasians ahead of me, 2 Mexicans, I'm 2 African Americans. They don't know if I'm African or African American, right? If I was born here or actually from Africa, they don't know that. I didn't have to say a word to anybody, right? But they can randomly, they can just pull me and say they want to see my ID, or they have to do it for everybody in line.
At the time, they should check everybody, right? Otherwise, there might be racial profiling that has its own issues, right? So they should check everybody, and I believe in that time, I think they did check everybody. But also too,
what are they going to be looking for? Because when you're flying domestically, all you need is your ID.
And that's what they're looking for. What ID do you pull out?
Okay.
So, for instance, in Texas, you cannot get a Texas driver's license unless you have certain documentation.
Okay.
So that makes sense.
And so if you don't pull out a Texas driver's license, so you pull out your Russian passport, you pull out your Mexican national ID. Suddenly, hey, show me your proof that you're here legally. I do believe, though, since that there was some case that came out that may have limited when they can do that. But you should also know too, Houston, New York, those are international airports, so there is, a DHS presence there. They're not typically going to leave the little areas.
Well, I'm just going to go fly to Hobby.
Yeah, and I met with an individual years ago who had been arrested because he went to the airport to pick somebody up. And he didn't have any status, and he was just there picking someone up, and he was the...
not even just picking somebody up. There was, I think, probably like 2 years ago, I had some stuff shipped to me from Nigeria, and I had to go to the Delta office at the airport to pick it up. The lady in front of me was a white lady, right? She was not asked any question. Rather, the guy talking to her was actually telling her, you know what, next time, don't do it beyond this, so you don't do this, you don't pay this, you don't pay that. But when it got to my turn, because I was black, the guy had to ask for my status. Yes.
Interesting.
Yes. he had to ask for my status. Fortunately, I had a copy of my US passport on my phone. I had to show it to him before I was allowed to pick my stuff. So really, it's not just going to pick up people at the airport. You can actually go pick something. But really, I mean, is it normal? Is it right?
But that is within Harris County. They're not supposed to be asking for your immigration.
They did ask me.
Well, this was a private company, though. You said it was FedEx, or?
No. I went to pick up my stuff from Delta at the airport. And definitely you have to go through customs to clear, to get the proof and everything. You have to go through customs to clear that. And this is even customs. Those questions were asked of me at the customs before they could sign off whatever, pay whatever I had to pay, now go to Delta to pick up what I had to pick.
And so
so what do you, because with the way the administration is right now, what do you advise people to do?
First, as always, talk to an attorney. If you don't have permission to the United States, or you're concerned about your status in the United States, you should always talk to an attorney first. I get so many stories of people that thought everything was fine. They leave the country, they try to come back, and they're not allowed in because something happened that potentially could make them lose their status. It's always better to just meet with an attorney first.
So even if you have a green card right now, you have a 2 years temporary, and you decide to travel out of the country, coming back into the country, they can't stop you for any reason and refuse your entry.
Yeah, and that's Customs and Border Patrol, and so they can. Well, I wouldn't say for any reason. I'm sorry. They can, talk to anybody, inquire whether or not they're, have. So let me take a step back. So citizens. Of course, they can come to Customs and Border Patrol. They should be allowed in because they're citizens. If you're not a citizen, every time you come back into the country, there's an opportunity there from there to question you. What we see a lot is individuals who've been legally in the country for years, maybe even decades, but something happened. It might have been very minor. It might have been some minor drug possession, or might have been minor theft, might have been some assault. Something made up.
With felonies, that is even still understandable.
Yeah.
With felonies, that is understandable, but a law-abiding citizen that goes his way, go to work, come back, you have your green card, you decide to go visit your family back at home, and you're coming back into the country, and you are being detained or you are being denied entry. What should that person do at that point in time?
So they should try, or the family should try, they should at first try to contact an attorney as quickly as possible. A lot of times,
how would you know?
And they usually have an opportunity to make a phone call, thankfully, and they usually call the family to let them know where they are.
So everybody has an opportunity.
Have the opportunity, but visitors don't.
And that happens a lot. We don't. A lot of times, somebody trying to enter on a visitor visa, they get detained at the airport. And we, do our best to try to contact, Customs and Border Patrol.
I called them for the case that I witnessed, my sister precisely. I called them. Yeah, they confirmed that she's in their possession, but they're not going to allow me to talk to her.
Yeah, and
they took her phone from her. They went through her phone.
Yeah,
that's some private stuff.
Yeah, and so unfortunately, what the government's position is that when you're applying for permission in the United States, you're not actually in the United States. And so you don't have a right to an attorney at that point. And that's their position. And I've had them tell me this for guys that have been in the U.S. for months. Until they actually say, hey, you're allowed to come in, their position is that person is not entitled to an attorney. But normally, if there's no issues with the green card, those people are allowed to re-enter the United States. Normally when we see the issues is when there's some indication of fraud, there's some kind of criminal history. That's usually when we see the issues, or something, maybe their card expired or something like that.
Gotcha.
But typically, if there's no issues, they're allowed entry, permanent residence.
So if I'm a permanent resident, and I know I have to be in the United States, right, because I'm now a permanent resident, but if I had to go overseas for work or business or whatever, how long can I be out for before coming back into the States? Because I think it's about 180 days, but I think some things changed, because I remember a few friends went out because they overstayed. They went for work, as a matter of fact. They were working for a U.S. company outside of the United States. When they wanted to come in, they stopped them, they denied their entry.
Despite the fact they went to work for a U.S. company.
They went to work for a U.S. company and they denied them entry. The company had to, step in before they can be allowed back in.
And so it's going to be a case-by-case basis. Rule of thumb is 6 months. If more than 6 months, there's probably going to be an issue. They're probably going to question you. More than a year, they'll probably say you abandon your residency unless you take some proactive steps before you leave. Say, hey, I'm going to work with this U.S. company. And there are times you can be outside the U.S. for more than a year, depending on your situation, depending on your circumstances. But it is a case-by-case basis. There have been cases where someone's been outside the U.S. for 3 years and they were found to have not abandoned their status. There's cases where people have been outside the U.S. for a few weeks and they're found to abandon their status.
Wow. Okay, let's clear this once and for all. Does ICE lay roadblocks?
Like checkpoints?
Like roadblocks. Like a stop and search kind of roadblock?
I have heard that they've done that. The thing that we see a lot more of is Customs and Border Patrol. They have the interior checkpoints. And so
Custom and Border Patrol. But if you are not in the border cities, like, do they still do that within like Houston area city?
It's not going to be within Houston, but what I've seen is people go to South Padre Island.
Yes, okay, that's closer to
on the way back,
Laredo. Is it Laredo or Laredo?
And going there isn't a problem.
Yeah.
But coming
back, that happened to me. My wife and I, we went in for Vicky's party, and then her 40 years, that's where she worked. So on our way back, we drove in, we thought we were still in America, right? So we were driving back, and they said we have to go through customs. And I was like, there was this is the same route we came in through. There was nothing.
Yeah. They don't care when you're leaving.
But fortunately, the guy just said he looked at us and they're coming. Let's go.
Yeah, and so there are, CBP does have interior checkpoints. I forget the mileage, but within the United States, it's a chance for them to get a second opportunity to, make sure no one entered illegally, no smuggling, things like that.
I know we have plenty of questions. If we continue with this, we never will stop. So that's why we're going to be doing this weekly. I will try as much as possible to bring professionals like Mr. Martinez here weekly. But one last, should have been one or two last questions, let me say, because it's a lot. It's a lot, because of time, of course.
Okay.
Bail. Let's talk about the issue of bail and what the city can do to protect their residents. And also bail. If there are funds out there for people that are already facing deportation proceedings. I know there are some pro bono organizations that can step in to help mitigate for these people. Just give us some insights as to what the bill requires and how they can apply for it. And then let's talk about what the city can do to protect their residents.
Sure. So when you're referring to bail, I assume you're referring to immigration bail.
Immigration bail.
And so the first thing I would want to caution people is that not everybody's eligible for bail. There are certain classes of individuals that are not eligible for immigration bonds, unfortunately. So there are two different entities that can issue bonds in immigration proceedings. One of them being ICE. ICE has the power to, in most cases, to either issue a bond or release somebody on what we call parole, which is release someone that might have to come back and check in. The judge, in some cases, can also issue a bond, depending on the facts of the situation. The judge may or may not have jurisdiction to issue that bond. The minimum bond is going to be $1,500. That's the minimum that the judge can issue. There is no maximum, so
the minimum is $1,500.
Yeah, there's no maximum, unfortunately. And in some cases, the judge or ICE can also add conditions to the release. What we sometimes see is that they put a GPS tracker on people, or they make those people come in once a month, once every 3 months, every 6 months, sign
like
in.
A parole.
Yeah, or sometimes they'll call the house, sometimes they'll check and see if they're home, just depending on the individual. And
restricted movement, basically.
Right, correct.
And this is like case to case? Or is it for everybody across board?
It's usually case to case. So, like for instance, if you have some kind of criminal history, ICE tends to not issue bonds, and certain criminal convictions will actually make you ineligible for a bond, just kind of depending. So, and also too, certain classes of individual aren't eligible for bonds. So it just kind of depends on everything, whether or not you are eligible for a bond. There is a bond fund in Texas at the moment. It is administered by RAICES, RAICES, and they are offering bond assistance. So they're a nonprofit group, so they don't charge for the service. You just have to make the application. You make it through their website. And so this is really great for individuals who do have a bond and just can't afford to pay it.
But so
Is there a criteria for qualification?
One of the criteria for qualification, before the criteria rather, is if someone I know is in there, am I gonna be a shortee for that person, or
So
that
if,
person can be their own guarantor?
And so it depends on who pays it. That's who's going to sign the paperwork, and that's going to be what they refer to as the obligor. They go down to the ICE office, they sign off on the bond paperwork, and that person is going to be the one that's the funds are returned to. That's the one that's going to be the obligor. Separate from that, typically when you're requesting a bond, they want a sponsor, somebody in the United States who has some kind of lawful status, whether it be an LPR, U.S. citizen. They want to know that if this person's released, they're going to show up to the next court hearing.
Okay, let's talk about the city protection, and then we can round it up for this episode.
Okay, and so actually Harris County and Fort Bend County have actually been really good about this. So what they're doing right now is they're changing some of their pre-trial intervention programs to limit the consequences of convictions and pre-trial intervention on non-citizens. So there was a case about a year or two ago that kind of changed the landscape for pre-trial intervention. For many years, pre-trial intervention was believed to not be a conviction for immigration purposes. The case, Matter Mohammed, I think came out last year, changed that. It said no, in certain cases, pre-trial intervention can be a conviction for immigration purposes. So the Fort Bend County DA and Harris County DA have been working really closely with immigrant groups in this area to change the wording and to change the conditions of the pre-trial intervention so it doesn't fall within Matter Mohammed, so it doesn't count as a conviction against a non-citizen.
Bravo.
They've been really great about that.
Unfortunately, guys, we have to go, but we promise you we will do our very best to keep bringing in people that can talk about issues as it relates to you and I. Until next time, thanks to our guest host, Mr. Shegun, and Mr. Jose Luis Martinez. And please, before I let you go, one thing I forgot, I know I'm rounding up, but one thing I forgot, I needed to be able to tell us how we can reach you.
Yes, and that's what I was actually about to ask you. So those individuals who are looking to speak to an attorney and can't afford it, I highly recommend that they go through one of the groups that we work with, which is the Houston Immigration Legal Services Collaborative, and they can be found at houstonimmigration.org online. They also have a hotline. This hotline will take an individual's information and then it'll send it out to my organization and other organizations. And this is for individuals that are looking for pro bono attorneys for individuals detained in the Houston area. And so that number is 1-833-468-4664. Once again, 833-468-4664. And we offer free pro bono services for individuals detained in one of the 4 Houston detention facilities. The one by the airport, off of Export Plaza, the 2 in Conroe, and then the facility in Livingston. So if you have anybody detained in one of those 4 facilities, we can offer services to them.
See? I told you Afrocentric is not playing. We're here to help you and serve you. And until next time, please, please, please stay out of trouble. Right? We'll see you.